Court does call the case of the People of the State of Michigan versus Denell Young.
What you're watching right now is not just a routine docket call. This is a real-time snapshot of how the criminal justice system actually operates when cameras are rolling and the stakes are very real. In just the first few minutes, we're already dealing with bond money, procedural missteps, attorney coordination issues, and a defendant appearing remotely while liberty literally hangs in the balance. These early moments matter more than most people realize. This case opens with Denell Young, and immediately the tone is set. Formal, procedural, but quietly tense. You hear lawyers asking for adjournments, judges probing bond status, and subtle questions that signal something deeper is at play. When a judge starts asking how a bond was posted and where the money went, that's not small talk, that's accountability. When cash bonds aren't symbolic, they represent freedom, leverage, and compliance. And notice how smoothly everyone appears on the surface. No objection, brief adjournment, polite exchanges, but beneath that politeness is a system constantly checking for errors, miscommunications, and financial clarity. One wrong filing, one misunderstood bond condition, and a defendant could find themselves back in custody without warning.
I'm Special Assistant Attorney General Mitchell Wood for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Young, who should be present via Zoom. Sir, can you please unmute, turn on your camera, and state your name for the court?
Denell Young.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I'm respectfully requesting adjournment. I believe I may have reached out to the wrong Assistant Attorney General regarding this case, and I just wanted to touch base with them prior to next steps. I have discussed this with my client. We're respectfully requesting a very brief adjournment.
No objection from the people.
Judge, no, I'm wondering, so Mr. Young is out of jail. Did he make bond? Did he make a cash bond?
I have his bond set at 3931, 3,931 cash. So I'm assuming that was posted.
That is,
Mr. Young, did you post that bond?
Yes.
I don't have in my file, Mr. AG, I don't have a receipt or anything, but I do see that that was the bond that was set.
Judge, I don't know whether counsel has spoken with Mr. Young about his intentions, whether he wants to pay that bond over. I know you have an expedited process to do that, and if he wants to do that, it would be great to do it now while we're still in district court.
To pay the bond over? Is that, Mr. AG, that's what you're asking?
Yes, I'm sorry, Judge. Yes, I'm asking whether the defendant desires to pay the bond over. I don't know if it was posted in his name, but it's a cash bond. If it's in his name, which it should have been, I'm asking whether counsel knows whether defendant wants to pay that over.
Well, in the condition of his bond is that they set the amount, and then some time ago the language that's added that if bond is posted, they're immediately to release it to circuit court. And then they list the case number that's part of the complaint. So that should happen. We've had some hiccups trying to make sure that the money gets over, but mostly it's worked. So I don't know that when he posted it, he knows that that's where it's going.
that was my understanding as well, Your Honor, that I did discuss with him.
To circuit court to the underlying child support case, not to the.
Yes, to the circuit court. And then I just deleted in terms of what I said the case number for this case, but.
Yeah, so we have no objection, Judge, to setting this over.
Okay.
Then. And counsel, the attorney who would usually be assigned to Washtenaw County, Sarah Brenner, I think is just about to get back into action. She's been off on a little extended leave. So I don't know who you sent it to. I could probably reach out to you. What is your last name again?
Pate, P as in Paul, A as in Apple, T as in Tom, E as in egg.
All right. And your first name, I'm sorry.
Natalie.
Okay.
Don't go through.
I will send you an email, Natalie, and we'll get the process going here.
This exchange might sound lighthearted, but it highlights a very real structural issue. The system runs on communication, and when people are out on leave or emails go to the wrong attorney, cases stall. Judge Simpson uses humor here, spelling names, laughing with counsel. But make no mistake, he's also quietly asserting control and keeping the machinery moving. When prosecutors mention that an attorney has been on extended leave, that's not an excuse. It's a risk factor. Delays can affect discovery timelines, defendant rights, and court scheduling. Judges often step in at moments like this to force coordination because otherwise, cases drift. The judge setting a firm date, May 22nd, 9 a.m., and continuing bond is not just administrative, it's a reset. Everyone now knows the expectations, no confusion. No, we'll figure it out later. This is courtroom triage done efficiently. And think about the defendant's perspective. From their side of the screen, their case progress depends entirely on emails being sent, names being spelled correctly, and attorneys reconnecting. That imbalance is built into the system. Would you feel confident if your freedom depended on whether two offices synced their calendars correctly?
Thank you, sir. Thank you, sir.
Oh, we put her email in the chat, so it should be there, Mr. Woods.
Perfect. Thank you.
Thank you. Thank you very much.
All right. May 22nd, 2025, 9 a.m. Bond continued.
Very
Thank you,
well.
Your
Thank
Honor.
you, Judge. And I assume the
Thank
AG
you.
will once again appear via Zoom, Your Honor.
Yes, sir.
We greatly
Absolutely.
appreciate it, Judge. Thank you. Thank you, Ms. Payne.
All right. Thank you.
Thank you, Mr. Young. You're all set for today.
Court calls the case, People versus Jack Richie.
Good afternoon, Your Honor. For the record, Attorney Russ Donaldson, P number 53660, on behalf of Mr. Richie. Will you state your name, please? Jack Richie.
Thank you. All right. You're requesting an adjournment on this?
Yes, Your Honor. I was just, the court actually just signed the substitution of attorney today. There's some discovery. I believe there's over 150 pages. There's some additional discovery that I'm asking for. Some body worn cameras, some in-car videos. There's an interview, I believe.
Now we pivot to Jack Richie's case, and immediately you hear a phrase that should always grab attention. 150 pages of discovery. That's not light reading. That's body cam footage, in-car video, interviews, reports, and timelines. And here's the legal reality. Defense attorneys must review all of it before advising a client. Anything less risks ineffective assistance of counsel. The attorney openly explains travel plans, and yes, even brings up an anniversary. But that's not unprofessional. It's strategic transparency. He's showing the court that this request isn't a delay tactic. It's a scheduling reality combined with due diligence. Judges hear hundreds of adjournment requests. The ones that get granted explain why the time matters. Judge Simpson responds with humor, but also approval. Why, this is a judge who values preparation over speed. Rushing a preliminary exam benefits no one, not the court, not the defense, and not justice itself. Ask yourself, if you were facing criminal charges, would you want your attorney rushing through hundreds of pages just to meet a date? Or would you want them fully prepared, even if it meant waiting a little longer?
I would be asking, and my client's already waived the 21 days, Your Honor. I would be asking the court to set this, if possible, to June 5th. I know it's a little bit extended, but I'm going to be out of the country for between.
People ask for their dates.
This happened?
Yeah. Okay. No, go ahead.
I'm sorry. I apologize, Your Honor. I'm going to be out of the country celebrating an anniversary with my wife that's been planned for a while, from May 22nd to June 1st. I would ask for June 5th. That would give me enough time to be able to gather all the discovery, advise my client in terms of his options relative to moving forward with an exam.
That's a good attorney. To the extent the judge was not going to give him time, he brought his wife in an anniversary. So that's who I'd be disappointing. I know, I see what you were doing.
I'm afraid of my wife, Your Honor. I just want to let you know that.
June 5th, 2025, 9 a.m. Bond will continue.
This ruling is straightforward, but it carries weight. When bond is continued, it means the court sees no immediate reason to restrict liberty further. That's not guaranteed. Judges can reassess bond at any appearance. Here, Judge Simpson signals stability. No escalation, no penalty for requesting time. Also notice the sidebar discussion about proposed orders. This is where real legal decisions get formalized. What's spoken in court matters, but what gets written and entered is what governs behavior. Orders control enforcement. Without them, words don't move the system. This moment shows professional trust between court and counsel. The judge allows attorneys to handle logistics, confident they'll follow through. That trust is earned and easily lost if abused. Court isn't just about arguments, it's about credibility. And in this moment, credibility is intact.
Your Honor, can I address one issue relative to the bond that I did bring up to the prosecuting attorney?
Yes.
Okay, thank you.
All right, the record should reflect we had a brief bench conference, and council's going to submit to the court a proposed order for the court. The court will then make a decision in terms of.
That is correct, Your Honor. Thank you for allowing us to discuss this matter sidebar. I'll have my office prepare the order. I'll go out and dictate it, and I'll have it sent to your clerk if that's okay via email for entry and approval.
Okay, very good.
Thank
All
you, Your Honor.
Thank you.
Yeah, that's perfect.
Okay. Court does call the case of the people versus Philip Carson.
Absolutely, for the people.
Senator Joseph, I'm on behalf of Mr. Carson, who is present. State your name, Philip.
Philip Carson.
Thank you.
Your Honor, if you want, I have documentation that I provided to the people about Mr. Carson's journey that I represented the last time from University of Michigan Psychiatric Services to Hillsdale, then back. He did get his GPS tether put right back on as soon as he got released, and he's back engaged with CMH. I provided that to the people. If the court wants it, I can provide it.
I don't think I need to.
Thank you. And then regarding today's PCC, we're asking the matter be set for a preliminary exam.
All right. And discovery is complete.
Yes, Your Honor.
And would the people have their witnesses available the 13th?
We can try, Your Honor.
What's the next available, Your Honor? Could we possibly do the 20th?
I can do the 20th.
Thank you, Your Honor.
Any objection from the people?
No, Your Honor.
Preliminary examination in person, May 20th, 2025, 9 a.m. That will be before Judge Perry.
Preliminary exams are critical. This is where the prosecution must show there is probable cause to believe a crime was committed and the defendant committed it. It's not a trial, but it's not nothing either. Witnesses testify, evidence gets previewed. Weak cases can collapse here. When Judge Simpson schedules this before Judge Perry and continues bond, it tells us two things. The case is moving forward and the defendant remains trusted to comply. Discovery being complete also matters. That means the defense knows what's coming. No surprises. For viewers, this is where many cases quietly pivot. Strong evidence survives prelims. Weak cases get exposed. If you were a defendant, would you want a preliminary exam, or would you push for a deal before ever reaching this stage?
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Thank you.
Oh,
Thank you, Your Honor.
Thank you, sir. Let's call the case of people, state of Michigan versus, it's a WeTech.
WeTech Inc., Your Honor.
Inc. Yes, okay.
Andrew Childers appearing on behalf of the people, Your Honor.
And Your Honor, Joe Simon, half of Mr. Ng. Mr. Ng, will you unmute and state your name?
We take
Okay. All right. Got it.
Mr. Childers?
Your Honor, at this time, people would be moving to dismiss this case without prejudice.
I'm assuming there's no objection.
No objection.
All right. This case is dismissed without prejudice. All right. Thank you. Court calls the case, People versus Alan Payne.
Absolutely. People.
Your Honor, Joe Simon on behalf of Mr. Payne, making his way to the podium. State your name, Alan. Alan Payne?
Thank you. We're looking for an adjournment.
Yes, Your Honor. I made a proposal to Ms. Londy, who's going to talk it over with her supervisor and come to a decision, we hope, on the next court date.
May 22nd. Will that work?
Fine with me, Your Honor. Thank you.
Yes.
May 22nd, 2025, 9 a.m. or as your invite indicates, bond will continue.
Go home.
Alan Payne's case shows another common courtroom reality. Negotiations happening quietly behind the scenes. When attorneys mention proposals being discussed with supervisors, that means plea negotiations are in motion. Nothing is final until it's approved. Judges often allow short adjournments for this reason. The court prefers resolution over unnecessary hearings. If an agreement is possible, the system encourages it, but never guarantees it. Bond continuing here signals no new concerns. The court sees no reason to change conditions while discussions continue. This is the slow grind of justice, not dramatic but consequential.
Continuing with the Joe Simon Show, court does call the case. People versus Michael Sanduski.
And on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Sanduski. Mr. Sanduski, when you approach the podium, please state your name.
Michael Sanduski.
All right, what are we doing on this one?
Asking for an exam, Your Honor. If we could have that same date, I don't think that other matter will actually go to.
Did he just do that? Did he just do that? He did, didn't he? Oh, yeah, I forgot. I'm in his world now. Discovery's complete.
Yes, Your Honor.
And Your Honor, I just want to say I did request the 911 call yesterday, so it should be here.
Okay. All right. Preliminary examination in person will be set May 20th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
And moving on to the next assignment. Court does call the case. People versus Deshawn Tomkins.
Joe Simon on behalf of Mr. Tompkins, go ahead and state your name.
Deshawn Tompkins.
Thank you.
And Your Honor, in this case, I presented a proposal to Ms. Lundy that she is investigating the things that I represented. And if I'll let her tell you how much time she needs for the next date.
Will the 22nd work?
That's fine, Your Honor. Thank you.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
By this point, a clear rhythm has emerged. Discovery issues, proposals pending, adjournments granted, bond maintained. For defendants like Deshawn Tomkins, this is procedural survival. Each adjournment is another step without escalation. But don't mistake repetition for insignificance. Every date reset extends uncertainty. Every bond continuation comes with expectations. Miss one condition, and the tone of the courtroom changes instantly. This is the quiet tension of pretrial justice. Nothing explodes, but everything matters.
Thank you.
Thank you.
Okay.
Is that it for you, Mr. Simon, finally? I mean.
Yes, Your Honor.
Right.
Thank you, Your Honor.
Sir.
Yes, sir.
Court calls the case of the people versus Angelica Towers.
And on behalf of the people.
Good afternoon, Your Honor. Edward Lucas on behalf of Angelica Towers.
Angelica Towers.
Thank you.
I'm looking to obtain the discovery in this case. I'd be asking for an adjournment.
Okay, probable cause conference, May 15th, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Matthew Fitzgerald. Two cases.
Absolutely, for the people of both matters.
Ready, Judge? Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Fitzgerald.
Torshio Feaster, Assistant Public Defender, also on behalf of Mr. Fitzgerald, on file number ended 507.
Your Honor, Mr. Fitzgerald is not here. However, there is a good reason for that.
Oh,
And I'd love to share that with you.
okay. Go ahead.
So Mr. Fitzgerald has a case in Livonia. And as you recall, due to a bond violation, you placed him in custody. During that time while he was in custody, I'm just trying to make the record clear.
You sounded accusatory, but go.
No. I'm not accusing you of anything.
No, I get thick skin. Go ahead, Mr.
Well, while he was in custody, he was scheduled for his sentencing in Livonia, which he then missed. So they issued a warrant. He turned himself in on that warrant, and they did immediate sentencing, and he is currently in custody because they sentenced him to 10 days in jail. So that is why he is not here.
This is one of those moments where courtroom banter suddenly collides with very real consequences. What's happening here is a classic domino effect across jurisdictions. Mr. Fitzgerald didn't miss court because he chose to ignore it. He missed it because he was already in custody somewhere else. But legally, that distinction doesn't erase the consequences. Warrants issue automatically when someone fails to appear. regardless of the reason, unless the record is crystal clear. Judge Simpson cuts through the narrative with sharp humor, but the underlying message is serious. Causation matters. Defense counsel is essentially arguing that one court's decision triggered a chain reaction that landed his client back in custody. The judge acknowledges it, but also reminds everyone that responsibility doesn't vanish just because the system overlaps. This exchange exposes a harsh reality of the criminal system. Defendants often move through multiple courts that don't always sync in real time. One missed date can snowball even when the defendant is physically unable to attend. Here's the question viewers should sit with. Should courts automatically coordinate custody status across jurisdictions, or does the burden unfairly fall on defendants to navigate a fragmented system?
Did you hear Elman's whole story? So Elman's whole story is, Judge, you tipped the first domino.
No, Your Honor.
That started this whole thing on the. Yes, that's exactly what you were saying. That's why Feaster is standing awake.
Well, Your Honor, he is in custody,
Feaster
and so
has
therefore
come
he's
nowhere
not
near the
here.
podium. Feaster's like looking at you like, go ahead, you say it, man.
Have I mentioned how good it is to see you again, Your Honor?
Probably should have led with that. All right. So you're seeking an adjournment.
If the court would be so kind.
Well, Mr. Feaster, are you seeking an adjournment?
Yes, please.
Then that I'll grant. All right. Probable cause conference on both of these cases, May 22nd, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Judge.
Thank you, Your Honor. 22nd.
Mr. Smart, he just said, I am not kidding. Court calls the case, People versus William Phillips.
And then on behalf of the people.
Good afternoon again, Your Honor.
Oh, no, he's back.
Again, always great to see you. Robert Ellman with and on behalf of Mr. Phillips. Mr. Phillips, can you please state your name for the record?
William Phillips.
Mr. Phillips is like, I'm not with him. No, go ahead. All right, what are we doing?
Your Honor, I was just appointed on this matter. I would be asking for an adjournment for time to get discovery. However, I'd also like to address bond whenever you would like to hear that from me.
Like to hear that. I'll adjourn this to May 22nd, 2025, 9 a.m. Yes, that's the bond, Mr. Earl.
Thank you, Your Honor. I would be requesting a change in the bond order to a no non-consensual contact. It's my understanding that the complaining witness in this matter has shared that request with the victim's advocate's office.
This is a critical bond argument, and Judge Simpson handles it with precision. The defense is asking to modify a no-contact provision, not eliminate it entirely, but shift control to the alleged victim. That sounds reasonable on the surface, especially given pregnancy, shared children, and prior cohabitation. But the charge matters. Strangulation cases trigger heightened scrutiny because of their inherent danger and recidivism risk. Judge Simpson explains something many viewers miss. Bond conditions aren't just about convenience or mutual consent. They're about risk assessment. Even if a complaining witness requests contact, the court must independently decide whether allowing it creates danger or undermines public safety. That's why the judge says he wants to hear directly from the person seeking the change, not through advocates, not secondhand. Bond modifications are serious, and the court protects itself and the parties by demanding first-hand accountability. This denial isn't punitive, it's cautious, and it shows how judges balance compassion with responsibility. Do you think courts should ever allow victims to override no-contact orders? Or is that pressure itself a form of risk?
And again, as you know, that would put the ball in her court as to whether to have contact with Mr. Phillips or not. So that's what we'd be requesting.
Okay.
I would also state that when did she do?
June 8th.
She's pregnant and due June 8th, and they do, how many other kids? Two?
Two.
They have 2 other children at home, so.
Honor, at this point, I would object. She did mention that to our victim advocate, and that was not, however, I just have concerns given the facts in this case and that strangulation. I think it's something that should be addressed at exam, or potentially in the future, but I don't believe it's appropriate to change that, provision at this point.
And if I could just add, Your Honor, this is, an older case. So they've been, to my knowledge, prior to the charges being filed, successfully cohabitating since the date of offense without any issues.
All right. I am disinclined to change that. I typically want to hear myself from anyone wishing to change the bond, even though they may communicate it. I then want to hear the people's sort of feelings on that, but I would need to hear from the individual themselves.
Thank you, Your Honor.
All right, so motion for bond reduction at this time is denied.
Thank you, Your Honor.
Here's the takeaway. Denial doesn't mean forever. It means not yet. Judge Simpson leaves the door open but insists on the correct process. That's judicial discipline. He's saying, bring me the right person with the right request at the right time. What stands out is how clearly the judge communicates expectations. There's no ambiguity, no guessing. Defense counsel knows exactly what's required to revisit this issue. And notice the tone. Light humor returns immediately after the ruling. That's intentional. Judges often diffuse tension after hard decisions to keep proceedings functional. Authority doesn't require hostility. This moment reinforces something important. Court isn't emotional arbitration. It's structured decision-making. And structure protects everyone, even when the answer is no.
You're all set. Thanks. And that's it for me, Your Honor. You don't have to deal with me anymore today.
Okay, so apparently on my face, it looked like I cared. No, okay. I'm sorry. I'm sorry. That was so wrong, Mr. Elman. Thank you, Mr. Elman. Always a pleasure, sir. I know that was. I feel bad now. What? Take it back. Court calls the case, People State of Michigan versus Michael Williams.
People.
You're standing against the wall.
Yep.
Oh, was it? Take care, Mr. Elman.
You too.
Something, Your Honor?
Pardon?
Just kidding. Figured I could get away with it a little. Just a little bit here.
Said pick on me today.
Oh, no, that wasn't.
Go ahead, sir. I
God.
called it.
Oh, thank you, Your Honor. Good morning, or good afternoon, maybe, please, honorable court. David Burgess on behalf of Mike, what? Williams. William or Williams? Williams. Okay, they said William in the thing. Mr. Williams, Your
You
Honor.
guys are close, I take it.
Yes.
All right.
Judge, I'll get on the record, but I just got this case yesterday, so.
Okay, very good. So you're looking, I need a green sheet, but you're looking to.
I'll fill one out, Your Honor, but I'm looking for an adjournment, and the next available date I have is the 22nd of May, if that's okay with the court. I know it's a little farther out, but.
So who said, is there a sign on the door that says, go and pick your own date?
It's on the other courtroom.
Oh, is that what it was?
Yeah,
You thought it was here.
I'm sorry, I must have read the wrong door. So.
Yeah, you must have. May 22nd, 2025, 9 a.m. Bond in this matter will continue.
Thank you very much.
Appreciate that.
I'll fill out a sheet. I'll meet you.
Okay. Court calls the case, People versus Jaylen Kendrick.
And then on behalf of the people, Your Honors. And Kevin, others on behalf of Mr. Kendrick.
All right, what are we doing?
Your Honor, we are going to be setting this matter for preliminary examination.
All discovery is complete?
We have all video discovery and all paper discovery. There is a 911 call, but we don't believe that that is essential, and we don't need that to continue with preliminary examination.
All right. So there will not be an adjournment for that purpose. Would the people have their witnesses available on the 13th?
We'll do our best.
Preliminary examination, May 13th, 2025, 9 a.m. That is before me. Bond will continue.
Thank you, Your Honor.
All right, thank you. Court does call the case. People versus Anisha King.
Richie McDuffie for people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. King, who's approaching now. Ms. King, can you sit for the record?
Anisha King.
Your Honor, there is some video discovery that we are waiting to receive. We're asking for an adjournment for that purpose.
Matters adjourned May 15th, 2025, 9 a.m. Bond in this matter will continue.
Your Honor, if I may briefly address. Your Honor, I brought to the court's attention last time, and I believe the people didn't take a position regarding Ms. King is asking the court to consider being placed on a sober link rather than a SCRAM tether due to some medical issues that she has. The court, we were informed when we were here by Ms. McDuffie that she had an outstanding warrant in the 36th district, and the court said that they would consider it if she was able to have that warrant recalled. She has been in the process of taking care of her matters in 36th district. It appears that she's set for court on the 6th and the 7th of next week for arraignments.
On the 36th district court matter.
Yes, but I will be clear to the court. The paperwork I have doesn't appear to be the one that Ms. McDuffie brought to my attention, but it's before the same judge, Judge Kennedy. And so I'm hopeful that when she appears on that, they can handle the other matter. I just don't have paperwork of the one that she was hoping to get resolved. I don't have confirmation of that matter, but she is set next week for 2 different arraignments.
And you're just looking for a sober link as opposed to
the SCRAM. But she is attempting to attend to all the matters and make sure that she complies with all bond conditions. And my understanding, she has not had any issues regarding bond at this point.
Any position from the people?
Your Honor, no, I know that the court's concern was the fact that that case was the high BAC matter. So I did provide Ms. Apple, I think she can share with her client the actual ROA from that case, unless she can call with the exact case number. I will be able to verify it as soon as it happens, because I can look it up and see that has changed. So I'll leave it again to the court.
All right. But she went down there to take care of matters at 36. It's clear.
It's clear that she has made progress, yes, and is set for 2 different arraignments next week. And I will give her the ROI to take with her with the new date when she goes on Tuesday or Wednesday, the 7th, to make sure that that also gets resolved if that is missing in some way.
Okay, well, she's headed in the right direction. I'm going to grant the motion for the change. I'll allow the defendant to be switched to a sober link.
This is one of the most instructive rulings of the entire session. A sober link is not leniency, it's precision. The court weighs medical issues, compliance history, and effort. Ms. King didn't just ask for relief. She documented progress, addressed outstanding warrants, and demonstrated engagement with the process. Judge Simpson explicitly says she's headed in the right direction. That phrase matters. Courts reward compliance. They don't just punish violations. Switching from a SCRAM tether to a sober link still imposes accountability. 3 blows per day is strict, but it adapts enforcement to reality. This ruling shows discretion at its best. Same goal, different tool. And it raises a bigger question. Should courts individualize monitoring conditions more often instead of defaulting to the most restrictive option?
Thank you.
But it's 3 blows per day.
Okay.
All right.
Thank you.
Thank you.
Hang tight for me because I'm going to print that paperwork for you. Thank you.
Court calls the case. People versus Latrice Lee.
National Money for people.
Afternoon, Judge Mike Gaddy, Assistant Public Defender, on behalf of Ms. Lee, who's approaching. Excuse me. Your Honor, maybe we could approach briefly.
Sure.
Thank you.
I mean, yes. All right.
Your Honor, there are some Secretary of State issues that I would like to further advise Ms. Lee on, because I think they are somewhat based on where her license was after this and where it might go with this arrangement. It's fairly complicated. I want to make sure she understands exactly what at least I believe is going to happen with her license.
All right.
Thank you.
And again, record should reflect we had a bench conference. I'll adjourn the probable cause conference to May 15th. 2025 at 9.
Thank you, Your Honor.
Thank you. Thank you, Mayor.
Can you come to my office?
Court does call the case, People versus Michael Lee.
Eddie, Assistant Public Defender. Monday, okay? 2 days from now, okay?
Okay.
Your Honor, I have had no contact with Mr. Lee. I've called him, called in the hallway, called in the court. I don't have any explanation as to his whereabouts. I'd ask the court for a show cause in this matter. But
Bench warrant will issue on 10,000 cash surety.
thank you, Judge.
That warrant will issue.
This is the hard flip side of discretion. When a defendant disappears, the court has no choice. Lack of contact, no explanation, and no appearance force the judge's hand. A bench warrant isn't punishment. It's a mechanism to regain jurisdiction. The $10,000 cash amount signals seriousness. Cash-only bonds eliminate third-party guarantees. The court wants certainty, not promises. What's important here is how quickly tone changes. No jokes, no negotiation, just enforcement. That contrast matters. Judges can be patient until they can't. This moment reinforces a blunt truth. The system offers flexibility, but only to those who stay engaged.
Does call the case, People versus Chad Major.
Andrew Childers appearing on behalf of the people.
Second, on behalf of Mr. Major, it's.
Aye.
My apologies, Your Honor. Mr. Major, when you were at the lectern, please state your name before.
Chad Major. All right.
Your Honor, we are asking for a preliminary exam to be set, to
All right. Discovery is complete.
the best of my knowledge.
People would have their witnesses available on the 13th.
Your Honor, would it be possible to go 1 week past that?
Any objection from defense?
No objection, Your Honor.
Preliminary examination in person, May 20th, 2025, 9 a.m. That is before Judge Perry.
So it'll be here at 9 a.m. in front of.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Thank you. Court calls case, People versus Makisha. Is it Melture?
Melture, Your Honor.
Melture.
Andrew Childers appearing on behalf of the people.
And Assistant Public Defender Jaylen, on behalf of but not with Ms. Melture, Your Honor. Informed me this morning that she was checking into the inpatient facility. I anticipate that within the next 4 hours, my office will have the facts from that. She has let me know that she is in the process of the entry at the moment. And I understand, Your Honor, that
what facility?
She's in an inpatient facility off of West Grand or East Grand Boulevard in Detroit. That's all I know at this time, Your Honor. I understand that we've adjourned this matter a couple of times so that she could get in. She had some problems doing so. As I stated, I anticipate some facts coming into our office that I can send to the court later on today as soon as I get them.
Well, here's what I'll do. I'll issue a bench warrant for a failure to appear, bond 10,000, cash surety. I will not issue that warrant until the 5th.
Thank you, Your Honor.
Court calls case, People versus Jodie Merritt.
People, Yagi, Assistant Public Defender, apologies, with and on behalf of Ms. Merritt. Your Honor, may we approach in this matter?
Pardon?
May we approach in this matter?
Yes, you may.
Your Honor, I know I made arguments at the bench regarding my client's medical issues and her all of the things she's done to stay sober. Specifically within the last couple of weeks, she's gone to AA meetings almost every day. She keeps a log. She has verified signatures. She set up an appointment for intensive outpatient. She, I know I said this at the bench, but just to reiterate for my client's benefit, she called down firms. They told her she was not eligible for inpatient. She has medical issues, which I won't go into detail on the record, but I did at the bench. And we were asking the court to consider continuing her bond prior to the bond violation hearing, which we are requesting at this. We would request that it be set for a bond violation hearing.
In your honor, as I indicated at the bench, previously we had accepted an offer in this case. That offer at this time is revoked. The defendant does not have a current plea offer. It may be made again at a later time, but right now it has been revoked. The offer in WI second is the sobriety or recovery court. The issue here is that the SCRAM tether does seem to confirm a 21-hour long tamper with alcohol detected. So people have concerns for the general safety of the public, as this defendant is currently on bond for a operating while intoxicated third offense with an alleged BAC of 0.17. I think it's 171 on the blood draw. And the risk that comes to the public, if this is a person that is on the most restrictive bond condition we can impose for alcohol, other than incarceration, who has an alleged tamper with that SCRAM, there's too much to ignore, and I am requesting the defendant be remanded at this time.
Court, having listened to argument and having examined the alleged bond violation in this case, does find that it's significant with reference to the tamper to the device with alcohol detected. And for those reasons, and the court, on seeing it initially, issued a bench warrant with no bond. At this time, the defendant's bond, the court is going to order the defendant's bond is revoked. And I will set a bond violation hearing as well as her PCC for May 15, 2025 at 3 p.m. Defendant is remanded.
This is the most severe outcome of the day, and it's grounded in evidence. A 21-hour alcohol tamper on SCRAM while facing a third offense OWI with a high BAC is catastrophic legally. SCRAM is the most restrictive non-custodial alcohol condition available. Tampering destroys trust. Judge Simpson walks through the logic carefully. Public safety, prior risk, violation severity. This isn't moral judgment. It's risk management. Once the court concludes, it can't trust monitoring. Incarceration becomes the only remaining control. Remand is not symbolic. It's immediate loss of freedom pending further hearing. This moment reminds viewers that bond is conditional liberty, not a right, but a privilege maintained through compliance.
Court calls the case, People versus Jacob Miller.
Assistant Public Defender Jaylen on behalf of Mr. Miller who approaches. And Mr. Miller, can you please state your name for the record?
Jacob Miller.
And Your Honor, I have submitted a finding and order on the competency to the court this time, asking for signature on that.
All right. Is there any other evidence regarding competency to submit to the court?
And nothing from the defense.
The court, upon reviewing the report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I have signed the order.
Thank you, Your Honor.
And you're requesting an adjournment. PCC.
We are, Your Honor. I'm requesting 3 weeks from the court so that I can work on a resolution.
All right. And what I will do is I will, hold on. I'll set a probable cause conference for May 22nd, 2025, 9 a.m. or as your invite indicates, bond at this time will continue.
Thank you, Your Honor.
Thank you, sir.
Is this for you?
Court does call the case on people Antoine Patterson.
Take care. Assistant Public Defender Jaylen on behalf of Mr. Patterson who approaches, Your Honor.
Antoine Patterson Sr. Thank you. You're requesting an adjournment in this case?
Yes, Your Honor.
Any objection from the people?
I'd like to address bond.
And if we may approach for that.
May 22nd, 2025, 9 a.m. May approach. Secretary, looks like we had a bench conference in this case, and it mainly revolves around the no contact provision. My understanding, the current no contact provision with Morgan indicates as allowed except as allowed by CPS. I will be deleting that except, provision except as allowed by CPS. My understanding is no objection at this time for the defense.
That is correct, Your Honor.
Make that change, grant, basically granting that exception to the motion.
This is a subtle but important bond modification. Removing CPS-based exceptions tightens control while clarifying boundaries. Everyone now knows exactly what no contact means. No gray areas, no loopholes. Judges often clean up bond language like this to prevent future disputes. Ambiguity breeds violations. Clarity prevents them. This is preventive judging. Quiet, technical, and effective.
All right, and we return to the 22nd.
Thank you, Your Honor.
And we'll continue. All right. Thank you.
This is for you, okay?
Oh, thank you, sir.
Thank you. All right, take care. Court does call the case, People versus Taiwan. Hey.
I do not with Mr. Jaylen.
That's because he's on Zoom.
I tried to reach him. Okay. I need to update contact.
Phelan, can you state your name?
Taiwan Phelan.
Your Honor, we are.
Okay, yes, go ahead.
We're going to be asking for an adjournment. I don't have contact information for Mr. Phelan, or I do, but it's disconnected.
All right.
Am I able to get his contact information on the record? Does that work?
Put it on the record.
Okay. Mr. Phelan, can you call the public defender's office so we can talk to you and have contact?
Actually, yes, call the public defender's office. He's at 14-2.
Okay.
All right, I'll adjourn this probable cause conference, May 22nd, 2025, 9 a.m. or as your invite indicates, bond continue. Thank you.
I'll talk to you, Mr. Phelan.
Okay.
Court does call the case, People versus Tremaine Pinder.
How about Mr. Pinder?
Tremaine Pinder. Thank you.
Your Honor, we're going to be asking for a very short adjournment. We believe there is more discovery and we have investigators working on it.
May 15th, 2025, 9 a.m. Or as your invite indicates, bond continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Joanna Reed.
Assistant Public Defender Jay Bellinger on behalf of Ms. Reed.
Your name?
Ms. Reed.
Johanna Reed.
Thank you.
And Your Honor, I don't know that I submitted a green sheet to the court, so I apologize. I just made first contact with Ms. Reed. She was on a mental health petition, so she was previously hospitalized. So I'm just asking for 3 weeks so that we can discuss her case.
Without objection, May 22nd, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Court calls case, People versus Deborah, Spears.
First, we get from people. Assistant Public Defender Hannah Apple appearing on behalf of Ms. Spears, who should be appearing via Zoom, Judge.
Hello, this is Deborah.
Do you have your camera, Ms. Spears?
It's phone.
No, I can't download Zoom on my phone for some reason because I owe Apple Network. And I can't figure out how to pay it.
Okay. So, Ms. Spears?
Yes.
You're requesting an adjournment.
Yes, Judge.
I'll adjourn your matter out May 22nd, 2025, 9 a.m. All right?
Alrighty, thank you so much. And I will make sure to have Zoom downloaded by then as well.
All right, very good. Thank you.
Thank you.
Thank you.
Court calls the case, People versus Carl Tesson.
Brian Boyd, Mr. Patterson is approaching, Your Honor. State your name for the record, please.
Protesting.
Judge, I'm asking for an adjournment. This is another matter where I need to obtain some video discovery to review with Mr. Tesson.
May 22nd, 2025, 9 a.m. as your invite indicates, bond continues.
Thank you, Your Honor.
Thank you.
What you've just watched is the real machinery of criminal court. Not TV drama, but real decisions affecting real lives. Across dozens of cases, Judge Simpson balanced efficiency with discretion, humor with authority, and compassion with public safety. We saw bonds continued, modified, denied, and revoked. We saw compliance rewarded and violations punished. We saw how preparation matters, how communication failures cost time, and how quickly circumstances can change when trust is broken. The broader lesson is this: the system is not random. It responds to behavior. Defendants who engage, document progress, and follow conditions are given room. Those who disappear or violate terms face immediate consequences. If you found this case as shocking or revealing as we did, make sure to hit that like button. Share your thoughts in the comments and subscribe to the channel for more jaw-dropping courtroom breakdowns and real-world legal insight. Court is adjourned, but the conversation isn't.